You said about the 20 minutes, right? So he had 18 minutes. I had much less time. And that's not fair.
Well, you're out of order right now. See, we have a gentleman up here who's ready to speak. He's got 2 minutes and 41 seconds. Now, you could share a minute or so if you want.
Well, let me get through my arguments, Your Honor, and I'll be happy to refer to
okay.
If it please the Court. I listened with great interest to Mr. Deschutes. What he essentially was saying in part of his comments was that he was urging that Congress would in effect be acting as a judicial body and making determinations as to who is eligible and who is not, whereas it's our argument that that is the province of the Court. He also talked about the idea of Congress passing laws retroactively deciding who is eligible. And that's how we get back into this problem with the minor parties. We have the Republicans and the Democrats. We have some independents in Congress, but compare them to the major parties, and they are powerless, except in a close vote, to make any difference whatsoever. So we still have the issue getting back that the courts need to be involved in this and need to take a stand to enforce the Constitution. Now, regarding the political question, it's our argument that eligibility is not a value judgment or a policy decision, as is required for the political question. It's a yes or no answer to a question. Is someone eligible subject to the evidence that's submitted, or is that person not eligible subject to the evidence? Okay, so it's not we would argue that, with all due respect to Judge Carter, that it's not a political question. With regard to the court's involvement in cases such as this, it's very limited, but we submitted the Cleaver v. Jordan case, which went all the way to the United States Supreme Court, which the U.S. Supreme Court refused to hear, allowing the affirmance of the California rulings, which stated that the Secretary of State had the right to remove someone from the ballot. Now, by the time this all got to be done, it was post-election, I understand, but they affirmed the right of the state of California in this case.
No, they just didn't hear the case.
Yes, they didn't hear the case.
They didn't hear the case. That doesn't mean anything.
Well, but they allowed the lower court decision.
Yeah, well, they do that. They do that all the time because they got a lot of other things on their agenda.
I understand, Your Honor.
You know, they've got plenty of work.
Your Honor, yeah, I'm sure. I'm aware that they do. Your Honor, in sitting and thinking while Mr. Deschutes was making his presentation, it occurs to me, and I don't have the experience that Your Honors do, but I've been doing constitutional law for 35 years, that on other issues, if we had brought it before the election, as I've done in other instances, then we're told it's premature because you don't know who's going to get elected, so you can't really challenge anybody's election. Then if you wait till after the election, then you're too late. The election is done in response to one of the questions about what the change point is, where the sea change is, and it's that. I would respectfully suggest, and my time is up and I apologize, that Your Honors review the Irby case, which we submitted, where there's a discussion about the problem with elected bodies making determinations as to who's allowed to run for what in the sense of ongoing political campaigns. And I thank Your Honors for your time.
Thank you very much.